licensing authority and what doesn't. But then we go to the next slide where we talk about the term breeder. What we have right now is we have too many animals on our streets, right? So what we've proposed is, right now we've been getting a lot of feedback on this. The intent of introducing a non-commercial breeder, a definition for non-commercial breeder, and then later prohibiting non-commercial breeding activity, is to preserve the ability of folks that want to breed different types of animals for whatever reason they may want, but ultimately to be sold for the purposes of carrying out the line, or producing more working animals, producing service dogs, whatever. We want to preserve the ability for Houstonians to do that, but we want to, with this definition of non-commercial breeder and the prohibition, we want to prohibit and hopefully decrease the number of animals that are brought into our doors every day, just because people don't appreciate that that's imposing a cost on not only bark directly, but because you're imposing a cost on bark directly, because you're bringing in styrofoam coolers and paint buckets of puppies and kittens, that's a cost that the rest of the Houston taxpayers have to pay. So what we have are, we've essentially said it's not okay to be a non-commercial breeder, and it remains okay to be a commercial breeder, as initially authorized by council back in 2007. We've added a definition for extreme weather conditions. I'm not going to read you that definition. You can see it there on the slide. But that the reason that we've added that is to basically say later on in the chapter that you can't trap animals of your own volition independently of bark when extreme weather conditions exist. Because we don't have the ability to go out and retrieve those animals during extreme weather conditions, and you can't just trap an animal when it's 105 degrees outside and just let it sit there. Yeah, it's just not humane at all. Going to the next slide, you see section 6-11. We've eliminated, there was a permit to keep milch goats. Chris, we haven't received an application for a milch goat permit in several years. We haven't, so it's essentially unnecessary for us to preserve that. So we propose that we eliminate it. We have made a revision to section 6-17 because that section formerly required that all quarantine animals be tattooed. The world has changed, and we've revised that to read microchipped. You can see a couple more of the reasons there. In section 6-26, we've introduced a definition for ownership, and what that is essentially any person who's encouraged the presence of any domestic animal on their property, residence, or premises by providing food, water, or other care, or has otherwise accepted caretaker responsibility for the animal for longer than 3 consecutive days shall be considered the owner of the animal. What we're going after there, and I know you guys in council offices will sympathize or empathize with this, is we get a series of calls is actually how this works. We get a series of calls into animal control, requests for us to take action in an area because a neighbor says that the dog down the street at 123 Main is allowed to run at large all the time. They're scared, or it's being aggressive towards people, or it's just a stray. So we take that information and we go down to 123 Main Street and we speak to the owner of that property and say, look, your neighbors are complaining about your dog, and their response is, well, it's not my dog, I just feed it. It's a stray, I just feed it. Well, we're adding this definition to essentially say that whether or not you claim ownership, the acts that you take determine whether or not you're ultimately accountable to making sure that animal, if you're going to encourage the presence of an animal on your property, you need to be accountable all the way through. To mean you can't allow that animal to impose a cost or a nuisance or a danger on your neighbors.
Chris,
yes, sir.
Is the verification for the 3 days, is that based on testimony by neighbors?
Yeah, I think, Sam, what we would do, I think operationally, is we would look at, oftentimes, as you know, for strays, we're not able to respond the same day, and several times it may take several different complaints. So we can look at a time series of the
Okay.
311 cases that we've got.
Mhm.
Yeah.
Okay.
And oftentimes, actually, I mean, the people will volunteer how long the animal has been there and how long they've been feeding it. So.
Okay.
Chris, is this going to, are you going to have this in line with the feral cat colonies?
Oh, yeah. That's a good, why don't we jump over, if you look at, because there's a lot of interplay, and we had a lot of discussion about this at the first stakeholder meeting, it's important to read section 6-26 in conjunction with section 6-22. And Xandra, one of the
Gotcha.
things after that last stakeholder meeting, one of the things that we've really tried to do is insert language, is to make sure that we're not unintentionally implicating humane organizations or rescue organizations or TNR managers with these types of regulations. So
Right.
if you take a look at 622, that's congregations of unconfined and licensed stray cats and dogs. What we've essentially done is that's essentially where it states that it's unlawful for you to create a congregation by providing food, water, shelter, or anything else. And that currently means 3 or more dogs or cats. So a defense to that is that the animals are part of a TNR program approved by the director. So that means that you're actively engaged in applying the TNR methodology, and we know that you're out there working on the TNR methodology.
Correct. Gotcha.
And then we've changed the definition, and you'll see this up in 6-1 if you guys want to flip back to that. We changed the definition of feral cat. What it means now is feral cat means any unowned, free-roaming, or untamed domestic cat. It used to read any homeless, wild, or untamed cat. And that was in
Chris,
Mm-hmm.
beg your pardon.
Go ahead.
I do have a question though on 6-22, and that is, what does the acronym IAW stand for?
In accordance with.
Yeah.
Oh, okay.
Did you hear that?
Okay, thank you. Yes, I did, in accordance with. I heard it. Thank you.
So you can see then that we stipulate that the person is placing the food. So there's the TNR exemption, and then that the person is placing the food out solely for the purpose of apprehending such dogs and cats and delivering them to bark. And I'm reading what would be the new language now, guys. Delivering them to bark, delivering them to a humane organization, delivering them to a licensed vet for sterilization as part of a TNR program approved by the director, or obtaining a rabies vaccination and current license issued by the city for such animals. So that's essentially taking ownership of those animals. So does that make sense, Andrew?
Yeah, I think that it would make good sense if you put some language in 626 that related back to 622, because essentially 626 is going to make them the feral cat colony managers owners.
Yeah.
And I don't think that's the intent of because
Yeah, you're right.
at least in the past, what y'all had was a list of further requisites for the colony managers, which you don't see here in 622. They would license the colony with bark, and bark would come out and then see that they all had the universal notch in their ear, that the cat had been spayed or neutered, and they weren't considered owners.
No, right.
They were the colony managers, which is a little bit different.
Right. Agreed.
Just a thought.
Agreed.
Not a big deal.
Specifically, the trap neuter, the unowned is part of the definition that we're including in that.
Yeah.
So it's implied in the definitions that there isn't an owner involved with the TNR program.
That's true.
And we also, it goes the same, the TNR is exempted from the ownership.
That's true. I guess we, yeah, good point, Xandra. We're going to look at, I think we'll look at what we've got. I think we get the job done now. It's probably a question of whether or not it's clear to the lay reader about that. So I think what we'll do is we'll take a look at the way that we define feral cat. We'll take a look at the way that we define ownership in section 6-1, and then we'll take a look at 626. Okay?
Perfect.
Okay. Okay, so then we go to the next slide, which starts off with section 6-31, and essentially what you'll see, guys, any place that we refer to an enclosure throughout chapter 6, we're basically saying that enclosure is built to comply with the building code, which really is kind of a way for us to say you need to check the building code to determine whether or not what you're constructing has different rules. For it. In some cases it won't, like a dog pen or cat pens won't, but it's essentially saying it's your responsibility to go refer to the building code to make sure that that you're complying with what might be in place, whatever the current version of the building code is. 6-38, this is a tricky one, I'll admit. So what we have right now is we have prohibition against roosters in what you're looking at right now. And I'll tell you, so this is where we are on roosters and hens. What we have, the council staff, and I don't know if you're aware with this, Sandra, they've been pretty aggressive in their PR work, so you're probably aware of them. You know that Hens for Houston has advocated for various changes that would allow for more folks to keep hens for various different purposes in the city of Houston. And they've been advised, the mayor has said publicly that we're not going to, we have worked to produce a draft of regulations that we think would accomplish that, but the mayor has stated publicly that it's up to Hens for Houston. She's going to act at the will of council, is the short version. And unless and until she hears from a sufficient number of council members that they're interested in engaging on this topic and reviewing it, then it's going to continue to be discussed by Hens for Houston with the various council members.
Gotcha.
So the reasoning behind the rooster prohibition is that roosters are a cause of many nuisances, primarily sound, but also other things such as getting off of people's property and that type of thing. But it's a little bit, because there are ongoing discussions with Hens for Houston and engaging with council members, that's please just star that as a special case that we're still working on. You won't see any other revisions in what we're presenting that would incorporate what Hens for Houston would like to see, that because of what I just stated. Now going to the next slide, which begins with 6-57. This is an example of one of those obsolete sections that we had in the code that just needed to be updated. It provided a special permit to own a wild animal, and we're removing it because we haven't issued a permit for this in 10 years, and you're not able to get, there are no other wild animals that would have been subject to this grandfather clause that are still alive. So it's completely unnecessary, so we're striking it. And again, we haven't received an application for this in a decade. Section 6-90, this section provided authority to veterinarians to issue pet licenses, and we've removed that. BARC has taken, has brought the pet licensing function in-house, and veterinarians are not required to purchase additional software or incur any additional cost of selling a license. So it wasn't being utilized, so we're essentially removing that as well. I think you'll see, hopefully you see that in
Chris, they're still required to do the reporting aspect of it, right?
Absolutely right. Absolutely right. What I hope one of the takeaways will be as people read this is that you'll see removal of either obsolete, impractical, or unutilized permitting requirements or other behavior that we required of various classes of citizens. And I hope that you also note that when there was an arbitrary standard that established the basis for regulation, that we've removed that in favor of standards that really allow us to attack the root cause of the various problems that might occur. And we'll get into that when we talk about the commercial pet service facility. So guys, I'm gonna try to be as brief as I can. So if you've got questions, we'll have as much time as we can at the end of it. So going to 6-101, language is added to make it illegal for an owner of a nuisance or dangerous dog to allow it to run at large. This is elevating the penalties. There was an elevated penalty for dangerous dogs previously. We've added 2 new classes or designations of dog, and this goes to the new tools for our animal control officers. Those are aggressive and public nuisance designations. So they have elevated penalties associated for allowing those dogs designated as either aggressive or public nuisance to be subject to higher fines as well. You can see we've already talked about non-commercial breeding and that it's prohibited. 6-122 is where we get into the commercial pet service facility license. So we've eliminated, what we've done is if you had 4 or more animals, you used to be required to get a kennel license. We also used to rely on the phrase kennel license, which meant that due to lack of understanding, people thought, 4 or more dogs, 4 or more dogs, then you were subject to the kennel licensing requirement. So that's an arbitrary number. That's an example of an arbitrary number that existed before. Folks also, we know of several different anecdotal reports of someone saying, well, I'm a groomer, I'm not a kennel, so I don't need to get the kennel license, when that wasn't the intent of the kennel license previously. You also, under the old provisions, it was prohibited to operate a kennel, which is really a commercial business. It was illegal to operate a kennel unless you were 100 feet away from the nearest point of human habitation, church, school, or hospital. That's another arbitrary standard that we could not find a rational basis to preserve. We consulted various veterinary literature and other peer-reviewed journals, and we could not find evidence that that vector transmission, disease transmission, other safety issues, declined dramatically at 100 feet, or really over any distance protocol at all. It was really directly related to the cleaning and care standards that are being utilized on the property itself. So, moving on to the next slide that starts off with 6-123, the first thing that you'll see is that we're not requiring a pre-inspection that is a prerequisite to receiving a commercial pet service facility license anymore. The reason for that is it's essentially not, what we're trying to do is move to a complaint-driven process. We want to make it as easy as possible for folks that are good operators to comply with what are a rational and pretty straightforward set of regulations. We want to focus our enforcement activities on those situations where we know that there may be a problem. So we're not requiring an inspection from BARC. The reason for that is that from past experience, most folks are in compliance when we go and check out the place. They're already in compliance with the various guidelines that exist that are published by industry groups and from our own regulations. So it's an unnecessary step and an unnecessary cost that we bore previously. We also talk about it in this section of the code that we'll promulgate guidelines for care or keeping. That's really going to be primarily related to guidelines that are published by various federal and industry groups. We won't be coming up with our own guidelines. They're going to be informed by objective third parties and experts. So you'll see a number of different, the guys in the council offices, you'll recognize most of the different requirements as consistent from other different licensing sections from the code. We need you to tell us who you are. We need you to tell us where you're doing business. We need you to tell us if your contact information changes. Basically, straightforward stuff. And that the license isn't transferable. It carries with the owner of the business and the operator of the business. If that changes, you need to renew. Now we've added two new sections. One, we've added a mechanism to suspend a license, and we've added a mechanism to revoke a license, and we've attached due process protections to both of those processes. The way that I would describe both of them is that we've established essentially what we consider non-negotiables. So your license can be suspended or revoked if these conditions are met. If you're not providing humane care, that means adequate food, water, or shelter for the animal. If you're treating the animals cruelly, or if you're keeping the animals in a way that disease could be transmitted or otherwise, encouraged, essentially. So that's after we receive a complaint about it. A bark animal control officer goes to investigate the complaint. They find that one of those conditions is met. Then we would take action, and you can read in the ordinance that we have to provide written notice that we're going to be taking action via a suspension or a revocation hearing. You're provided notice that you can have legal counsel there if you would like. And you guys recognize, I think, the hearing process. It's similar to other places in the code. And then the hearing is going to be conducted by municipal court's hearing officer. It won't be conducted by someone in ARA. So it's a disinterested third party throughout. And then there are various appeals that are available. So then finally, we have those three non-negotiables that I've just finished describing. Then we have another related to nuisances, and this is primarily related to sound. So you can have your license revoked or suspended if you have 3 convictions of violations of 30-3 of the code, which I am more familiar with than I would like. So if you have noisy animals, and we come out in one 12-month period, and we issue a citation, that citation, you're later convicted for that offense, and that happens 3 times in a 12-month period, then we can we can pull the permit back, the license back rather. Now that means you've got plenty of options to take advantage of the judicial process there. So you can have jury trials, you can have trials by judge, that type of thing, and all of those, you need to be found guilty 3 times in a 12-month period. That is a hard thing to do in practice. But those are the basic stipulations around the complaints that we're going to follow up on, and that's what I was talking about, substituting regulations that really address the root cause of problems that may arise, rather than relying on what was a blunt and arbitrary policy tool, which was the distance requirement. So there's a note here that a suspension is different than a revocation. We have the ability, if a license has been suspended and then we receive notice from the license holder that what led to the suspension has been corrected, then we have to respond within 72 hours for a reinspection, and so long as those issues have been addressed, then we reinstate the license right away. Now, if you have your license revoked, you will be prevented from applying for a new license for 1 year. I think I've just covered most of the salient things related to commercial pet service facility. So if we go down to the slide that begins with section 137, impoundment. What we've recommended here is that on every first impoundment, an unaltered dog or cat will be altered at the owner's expense. That means they can arrange for those services through a private veterinarian, but they'll be responsible for proving to us that they've had that done.
Chris, do you want comments now, or do you want them held?
We're almost at the end, Andrew. Are you cool with holding it, or we can take it now?
Sure. No, I've got notes. I'll wait.
Okay. So I think you guys can appreciate what we're trying to do there. We've got too many repeat customers and too many one-time customers that still allow their animals to reproduce and produce stray animals. So we're trying to remove that. And turning in an animal is non-priced to the person that is turning it in, but there's definitely a cost associated with it. So what we're trying to do is remove the ability of the owner to impose further costs by allowing that animal to continue to reproduce. 6-141 is really kind of a policy statement by us. It's really codifying what is already practiced, but we will not adopt or foster to any person that's been convicted of animal cruelty. We have an appeal process for persons that are denied an application for these reasons. There's been draft legislation that's been presented at a couple of the most recent legislative sessions up in Austin that hasn't made it to a vote yet. We would like to see that advanced, and what we're trying to do is provide a local example of somebody that's already doing something like that. Moving to dangerous, aggressive, and public nuisance dogs. Aggressive and public nuisance are the two new categories that we've created. What we're trying to do is fill the gap. Right now, our animal control officers are unable to do something if they have a report of an animal that's running at large or that may have attacked another animal. We essentially, their hands are tied a little bit in that they can't impound that animal or force the owner to take action unless they see the animal at large at the time that they respond to the location, or unless that animal has caused serious bodily harm via an attack. Those are the only times that we can really take action. So the aggressive dog, I'll let you read the stipulations there, but essentially if your dog is aggressive because it's bitten someone 2 times previously, or if it's attacked or harmed another animal, if it's been threatening and we have a series of complaints about that, if HPD tells us that this animal is aggressive, then we can initiate a hearing to designate that dog as aggressive. And then there are various keeping standards that have to be complied with by the owner, and we've already discussed the elevated penalties. And if we go to dangerous dog is largely the same as it has been. That's a definition that we lift from the state health and safety code. A public nuisance dog is this is different from the aggressive dog in that if an animal is a nuisance in that it continually or repeatedly runs at large, if an owner doesn't prevent the animal from making deposits on other people's property, if the owner refuses to fix their fence and that's the reason that the dog keeps getting out, if they're or if they otherwise just interfere with the enjoyment of the use of the right-of-way, then we can initiate a hearing to designate that dog as a public nuisance dog, and every day that the issue that is leading to the nuisance, for example, a broken fence, every day that condition exists is a separate offense, and then there are different new consequences for allowing a dog that's been designated as a public nuisance to run at large. Okay, so I think we've covered aggressive and nuisance dog essentially. So just if we go to the conclusion slide, and this is going to kind of the takeaways that I was referring to earlier, what we're trying to do is eliminate regulations that were on the books that didn't make any sense or were obsolete. We've inserted new regulations that, we have at least 12 businesses operating in town, right, more than that really. Every Petco or PetSmart that operates a grooming facility right now, like the PetSmart over at Taylor and I-10, is in technical violation of our kennel ordinance right now, our kennel license ordinance right now, because they're right next to a restaurant. We don't have complaints about those businesses. By all accounts, they're good operators. So we're getting our regulations out of the way of good operators and implementing language that allows us to focus on the problems that exist. So where we go from here, we've got a stakeholder meeting tonight over at the Houston Permitting Center. starts at 6:30, goes till 8:30. And we'll be taking this we'll see how tonight goes, but I think we're ready to take this to council committee, again, contingent on how tonight goes and the additional feedback that we get. And we're looking at going to public safety. So, Zandra, I know that you had some questions.
Yeah, a couple things. On 6-120, you have non-commercial breeders banned, but commercial breeders are allowed. Now, I understand where you're coming from, Chris, where there are some families that they just breed their own dogs to give to other family members, and what they have left they bring to you. That's frustrating. But with a broad brush, you're also eliminating responsible breeding of someone's dog that is, for example, a confirmation dog that is a proven dog, or in the case of dogs that I like to work with are working dogs. Genetics is the key factor in if your dog is going to track. I track with my dogs. They track human scent.
Right.
And so in fact, most of the people I track with have intact dogs, and they will breed that dog to get another tracking dog in the hopes that they have a high drive, good working dog.
Sure.
And I think when you have a broad brush and you take them out of the equation, you say to them, okay, if you sell your dogs for $1 and you get a commercial license, you're okay, but if you breed your dog to get your next line of good tracking dog, which, by the way, is how we track human beings when they're lost.
Mm-hmm.
My dog, I can earn titles, but I also have a function to give back to society. I don't think you want to do that, so I would hope you would consider trying to carve out an exception for those responsible breeders who are not littering Bart with unwanted puppies.
Right. So,
I think.
how do you obtain those dogs?
How do
I mean, I know that, so in the case of a tracking dog, like the example you just gave, someone wants to get another tracking dog, so they breed their dog. What happens to the rest of the litter?
Well, as within any good responsible breeder, the rest are they don't cull them out and kill them. They would place them as pets or use them for other things. Just because a dog may not have a nose doesn't mean it might not be a really good obedience dog or something like that.
Sure.
Or it might be an excellent therapy dog. There's so many functions for the working dog that I personally have. And by the way, I have 3.5 dogs. I don't actually live in Houston, but all my practice is here. And all of mine are rescue dogs.
Uh-huh.
So I don't have any dog with a lineage. But I have thought, maybe someday I'd like to get a really proven working dog out of a working dog line. And I would hate to see those people in a broad brush be excluded because they're not your problem. Your problem exists because people are indiscriminately breeding dogs and they don't have, real places for them. And I appreciate that. I would not want to be on your end getting baskets of kittens and puppies and then thinking that they're all going to be hunky-dory. And they're not. Most of them don't get out of there. So I get it, but I would just hope that y'all would consider making an exception for that person who's what is in the AKC world they call them hobby breeders, where they're actually breeding to have their next line of whatever it is.
Yeah, Zandra, what would you mind? Would you mind maybe thinking about that and sending us maybe an idea about how you might carve out? I mean, I presume that there are. Like perhaps it's the AKC, perhaps there are other little groups that, not, little sounds like I'm minimizing it, I'm not. There are other groups that I'm not aware of that provide some standards or something like that, or maybe there's a process.
Yeah, I'll definitely be happy to do that. And then the other correlate to that is in section 1-37. B1, I think to require an owner to alter their dog the first time it gets out is a little harsh. I can understand putting that on the second time, but the first time is a little harsh. And I know it's annoying as heck to get in an intact dog that's been loose, but by the same token, not everybody is the person who is the low-life person who's out there just letting the dogs wander around and breed indiscriminately. That first-time person we're not perfect, and the law doesn't require us to be perfect. So if we make one mistake, I just don't see the harshness of off with the body parts for one mistake. I can understand it for two. I get that. Just a consideration.
Okay.
And then the part, I guess, that I have the most concern with is if you look at the aggressive dog definitions. Chris, if you look at section 1 in the where you describe the aggressive dog means that number 1 has attacked or bitten any person.
Mm-hmm.
If that dog has attacked or bitten any person, it would really be in the dangerous dog category, not aggressive dog. So I think you're creating a conflict in your law by putting attacked or bitten, because keep in mind, a lot of people don't know this, but state law provides, and the city law tracks the state law, that a dog can be deemed dangerous and it never touches another human being. So and that is in Section 822. There's a definition where a dangerous dog is one that attacks a person and causes injury. That means like a nip, a scratch, or injury that is not serious, okay? But the second part of that is a dog that commits an unprovoked act, not an attack, an act, which causes a person to reasonably believe that they're going to be attacked. So a dog can be deemed dangerous that has never touched another human being. It's based on the subjective perception to whom the act was directed. Does that make sense?
Yeah, I hear what you're saying.
You're creating the conflict by including that dog, an aggressive dog, when that dog would already, by definition and state definition, be in. As a matter of fact, let me take it a step further. State law will not allow you to make a lesser definition for a dog that has bitten than state law. So this is actually in contravention of state law, that first part of it. So you really want to take that out. And then you also have... Go ahead. I don't want to just hog all the time.
I just wanted to. wanted to agree with you, because I personally have been in both situations. But I also wanted to make a point to what. I'm sorry. This is Edna Complex, Councilmember Noriega's office.
Thanks, Edna.
So I think she makes a very valid point between the difference of aggressive and dangerous. But I also want to point to the language of where it says that there have been 2 previous occasions, and I think the language needs to include that they were reported, because a neighbor can say, give you an anecdotal story, but if they haven't reported it, then to me that would be very different. And I want to know that if some action has to be taken against my neighbor for their dog or their cat or their aggressive animal, that I can say that I had actually reported it. Now, whether they were given a citation for it or not is different, but somewhere on the record it shows that somebody did report that there had been an incident of especially of an aggressive dog, because an aggressive dog doesn't have to bite you in order for you to feel fear of it.
Hi,
Correct.
this is Candace Gant-Brown.
Hey, hang on, guys. Hang on, guys. 1 second, guys. Go ahead,
If I could
Candace.
just respond real quick, that if you keep reading that line where you're talking about the definition of aggressive dogs, and the animal has attacked or bitten on 2 previous occasions, the final portion of that sentence is that
Correct.
such occasions were documented by bark. So does that address
Right.
your concern?
Yes.
Well, yeah, and the documented is also going to.
Correct.
One at a time,
And the
please, guys.
documented also, it means reported, right? You all have a record that it was reported,
What?
and not necessarily that a citation was issued,
No, we
but
can't.
that it was reported.
Edna, we can't document unless we know about it.
And
Right.
Okay,
there's no
that's
use
good.
of the word citation
So,
or
Chris,
conviction.
the other thing in that sentence is that you have aggressive dog is an animal without provocation, has bitten any person or animal. First of all, you don't have that limited to domestic animal, because, nor do you have it limited to place. If my dog goes after a squirrel in my own yard, by definition, you could deem my dog aggressive. My dog's going to go after a squirrel, quite frankly.
Right,
And
right.
Even if also if a loose cat comes in my yard, woe be unto that cat.
Right.
So I think, in fairness,
Yeah,
to
that's
dogs
not
and their
what.
owners,
Yeah, that's not what we're going after. Right.
I know. So,
Yeah.
but remember that in the law, the expression of something,
No doubt.
you want to make sure you exclude that which you don't want to cover with the broad brush.
Right. Okay.
And then,
I just want to make another point. I have to leave because I have to go to begin our covering the council meeting. But Chris, I wanted to know, because Bark is going to be represented tonight at our PIP meeting. Are they going to talk about these changes that have been proposed, or trying to decide whether to go to my PIP meeting or to the meeting downtown at the permitting center?
We're-
Are they going to talk about the changes that?
No,
at
we need
that
to
meeting?
go to the
That wasn't
stakeholder
what they were
meeting.
asked to do. They were just asked to go there
Okay.
and put on a general presentation, so that's what they're gonna do.
Yeah, and that was Chris Glasser was just saying that it's going to be a general presentation of animal laws and kind of about bark and that type of thing. So the recommended.
Okay, well, just
But what you could do, what you might tell the folks that are there, is that we have proposed revisions and we have our website, and if they want to keep track, we've got a video archive of our first stakeholder meeting on our YouTube page, and we're going to have the same video archive of tonight's meeting on our YouTube page, and you've got all the material on our website that people can consult. if
okay.
they
Well,
want.
okay. Well, that's very good. I'm going to attend the stakeholder meeting, but I'll tell my super neighborhood president, and he'll pass that on. And thank you all for your work. I have to go up. Thank you again. I will see you all this evening.
Thanks for your time, Edna.
Thanks.
on section 2, you have the section 2 to me is a quagmire, because what I've been doing this for almost 10 years.
Where
what
are
I've noticed
Xander,
about
where are
dog
you?
cases
Where are you?
under the definition or the explanation of what an aggressive dog is.
Okay.
Section 2.
Okay.
What I've found is that dog cases, by and large, are much more about people than they're ever about dogs.
No doubt about it.
And sometimes you have neighbors that are in conflict with one another, and the dog becomes the collateral damage. Why not, instead of having a section like that, because what you're wanting to do is to deem a dog aggressive that's in its own yard, as long as the enclosure is not sufficient to ensure the safety of people and animals. I can't disagree with that. I want that too. But why not think about having a minimum standard for enclosures? Because that way we don't have, right now, it's kind of willy-nilly of what is an acceptable enclosure. A 4-foot enclosure might be great for a Chihuahua, but it sure the heck wouldn't be for a tall dog. Do you see what I'm saying? And then that way people will know what's required of them. Hey, I need a fence of this kind of construction and of this height. And while I know you make those requirements for secure enclosures, it would be good to have a minimum requirement for a fence for a dog. Do you see what I'm saying? That way you don't have people's dogs being deemed aggressive that's in their backyard, and they don't even know what would be, quote unquote, sufficient to ensure the safety of persons, because you haven't defined it. You see what I'm saying?
There are places that have tried that, and it hasn't been very effective. In order to have the standards for an enclosure, then we more or less have to mandate that everyone have an enclosure, and that's something that we weren't willing to look at this point. It's based on breed, obviously, and based on activity. We don't want to try to set up regulations based on that broad a brush. We'd rather have it a little bit more subjective so that we can address individual animals based on their needs. If you've got a dog that knows how to climb, for example, a 6-foot fence isn't going to help. But so
Sure.
we don't want to make minimum standards. We want to be able to address each case on its merits and on the basis of what the dog is capable of and what the dog's breed and behavior would make it a secure enclosure or an enclosure that it can't reasonably be expected to be out of. So that's why we left it that way.
I understand that, but when you're trying to, I'm just saying, and I'm not trying to be argumentative, when you're trying to enforce the law, if it's vague and it doesn't outline what the standards are that a person must meet to be okay, then you have problems with enforcing it, and it'll be enforced indiscriminately or, kind of willy-nilly is all I'm saying.
Yeah, I understand that, and like I said, it's just difficult to set up specifics on enclosures when you have so many different animals. We're going to base the enforcement on whether the animal can get out of the enclosure, where the enclosure is in a dilapidated condition. We'd just rather be able to assess each case individually than to try to make a set of standards for an enclosure.
Yeah, that's one of those tough things to capture and create an exhaustive list without leaving things out if we're not somewhat subjective. Do we need to look at inserting like any type of reasonableness standard or anything like that there?
The language that I tried to use as far as the enclosure for the aggressive dog tracked the language for dangerous dog in state law. So, and state law refers to enclosure that acts or causes a person to an enclosure reasonably certain to prevent the dog from leaving. And so that's kind of the same standard that I tried to apply to aggressive dog. So this objective standard already exists in state law, and that's basically where I tried to go and why I did that same language with aggressive dog.
Okay.
And I think in number 4, where it says law enforcement officer or animal control officer has reason to believe that dangerous disposition is likely, that's very vague. It's very nebulous. What is it that would trigger that in fairness so that dog owners would be on notice of what they need to do or not do to come within the ambit of that clause? And I think it's very vague. I just, what concerns me is, again, these cases are way more about neighbors. Neighbors that are familiar with this process, believe me, they will make sure they call in 5 times, not 2 times, if they are, in conflict with another neighbor. And that's just the problem with these things.
Yeah, and I think
if you look at, go ahead.
Well, you're right, and we deal with that on a daily basis. So we know that's absolutely true. And that's really the entire reason why we went with this designation via hearing officer as opposed to unilateral action taken by BARC. And why the people who are subject to the hearing have the ability to bring legal counsel. They can tell the hearing officer, look, my neighbor, we've been fighting going back and forth for 5 years now or whatever. And I think having a disinterested third party make the determination decision after they've been presented with the evidence that can be provided by BARC, by HPD, by the owner, the post office, by a neighbor. You know what I mean? We're trying to provide as much protection by utilizing that disinterested third party that's ultimately responsible for making the determination.
If you look at public nuisance dog, that's overlapping too, because you're in conflict with 2. 2 says attacks domestic animals. Well, is that going to be a public nuisance dog, or is it going to be an aggressive dog?
Yeah, so we'll take a look at dangerous, aggressive, and public nuisance and make sure that we don't have an unnecessary or unintentional conflict there, Xander. Thank you for pointing that out.
Okay.
And we'll refer back to health and safety code too.
What? I can't hear you.
I said we'll refer back to the health and safety code to make sure that we're not damaging ourselves in any way by that too.
All right, and then 6-154 requirements of a dangerous dog. Y'all changed the requirements for the insurance. So there's no state requirement that the insurance has to specifically say it's for dangerous dogs. Homeowners policies are of 100,000. Usually they're even bigger and cover dog bites. When you put language like that in, you're essentially assuring the death of the dog. And remember, in fairness, dangerous dog definition includes dogs that have never touched another human being. So to have that person have to go out and get specific dangerous dog insurance costs at least $2,500 a year for that. And that's for a dog that's never touched another human being. That's pretty harsh.
Well, I'll tell you the way that we've been interpreting the way that we've been utilizing the dangerous dog. Correct me if I'm wrong, Chris, but it's essentially after serious bodily injury has occurred, right? No. So he's shaking it. So
No,
I'm wrong.
we enforce the dangerous dog law as it's written by the state. There are issues that we've resolved where the person has believed that the animal would reasonably do harm to them. Normally, that's a case where the animal was declared dangerous, attacked another animal, and they were involved with that situation. But no, we definitely go with all of the definitions the state uses. The reason that we put the language in about the insurance is because it's been our experience in doing this for some time that the insurance companies, if they know that a dog has been declared dangerous, are not as willing to insure that animal. We want to ensure that the person that has a dog that's committed an act that went through the whole procedure, the whole legal procedure, the whole appeal procedure, is going to be covered by insurance as required by the state. Because what we found is when the insurance company actually knows that the dog is dangerous, they're not willing to cover it under the regular homeowner policy. We found that a lot of insurance companies, if they're notified ahead of time, are perfectly willing to put a notice on there that, yes, we're aware that the dog's on there. Frequently, insurance policies don't include dogs at all. And we've looked at a lot of these. So we
yeah,
put
but
the language
the
in there
reason that they
specifically
won't
for
insure it is because BARC takes another step, which is also not in state law, and they put them on notice. BARC honestly should not be communicating with the dog owner's insurance policy. They should be looking at the policy. If it provides coverage, it provides it. Once you put an insurance company on notice and you want them to give you some language in a letter, it ain't ever going to happen. The insurance company will never say to you and give you a policy explanation that they cover for dog bites, because they always want to have an out, even though they cover for dog bites. You'll never get them to put it in writing.
So
they simply won't.
But we have. So
what?
We have had them put it in writing before.
Well, sure, but that's not your. You get that from other carriers. They're not homeowners carriers. There's several carriers that write that kind of insurance. You're 100%
we're
correct.
aware of all
It's
of that,
extremely
and
expensive.
we have done this before. We've had the insurance companies get in touch with us, and we've explained the situation, and we've gotten the letters from the insurance companies on the insurance company's letterhead. What we want is to protect the public from a dog that's been declared dangerous as much as we want to keep the dog alive. We don't go after dogs and ask them to be euthanized, but we do want to have some kind of coverage for people that insurance is going to be in place and isn't going to be refused if they go to make a claim on it.
So bottom line, what we care about, like Chris just said, if an attack occurs, if someone is harmed through no action of their own, they have appropriate recourse that they can take, and that there's appropriate and sufficient insurance or other financial measures for them to be made whole. So that's our primary concern. Xandra, we've got another division in our department is referred to as insurance management. They do all the non-benefits related insurance. They're the ones that set up our property and casualty portfolio for all the city properties. We can ask them to take a look at this and guide us on this. So we'll get some experts on it.
Yeah, and I do admit there are plenty of homeowners policies that specifically exclude dog bites.
Yeah.
But there are plenty of them that don't, but very few of them. I have yet to find one that are going to put it in writing. Now, you do have other insurers that specifically write insurance for dogs, and they'll put that in writing. There's not a problem with it. but it's usually starting about 2,500 a year.
Okay.
It's crazy.
Now, there are various
So-
scales on that. We've got a lot of different.
What?
There's various scales on the insurance.
We're going to take a look at that, Xander. We'll do some homework on that market.
Okay, that's fair.
So we're 10 minutes over. I think anybody that needs to leave, you guys can leave. How are we on your stuff, Xander?
Hey, Kurt.
How are we on what?
Well, Xander, can we pause? It sounds like Sam has a question. Is that all right?
Yeah. I'm wondering about the 100-foot rule, and how does that affect the folks that have livestock?
The livestock provisions, Sam, aren't changing outside of the fact that we've extended a couple of the prohibitions to like the milch goat example, sheep,
We specified.
Wild
that
rams.
Includes pot-bellied pigs, and
Yeah.
there's a few animals that are considered domestic livestock that weren't in the ordinances and addressed, so we just want to make it inclusive.
So the 100-foot exemption still applies, Sam, and so do the
5,000.
the 5,000 square foot minimum lot size, and then the linear progression that you have to go through to add additional head.
The manure, the feed,
Okay.
and everything.
Yeah, so we haven't changed anything. If nothing else, we've made it. We've prohibited some additional animals from being kept within the city limits, and then we've covered some additional types of livestock in that 100-foot. And
Okay.
the minimum distance stuff.
All right. Thank you.
Okay. Xandra, how are we looking?
Well, the only other thing that that I would see as a concern is I understand that as a city you want to say that you can't have a dangerous dog come into the city that's been deemed dangerous elsewhere. But if it's going to be monitored by the city, like our dangerous dogs that are deemed dangerous here, I don't really see why you would exclude that. That's just I mean, I know a lot of places do, but I would think that they're going to come anyway. You know that as a practical matter. I would think that you would want to control, monitor them rather than them be under the radar. That's just a thought.
Well, the deal is, if they're following the law, if the owners are being lawful, they're notifying us already. They're gonna notify the animal control agency where the dog has been declared dangerous, and they're gonna notify us that the dog would be coming in here. Our issue is Houston was becoming a popular destination for people with dangerous dogs because so many places do prohibit them. But we wanna be able to protect the people in Houston as much as possible without overtaxing animal control to try to enforce something that happens somewhere else. So we would prefer that they not come into the city if we can do that. We're regulating our animals that are here and the people that live here, but we don't want to take on other people's issues simply as a refuge for dangerous dogs.
I guess my concern is I really wish that there were a division between the definition of dangerous dog, that a dog has actually had bitten someone, versus a dangerous dog that has not ever touched a human being. Because that's a very harsh rule. It's a very low bar. In fact, there is no bar.
Got to be
Any
addressed
dog
at
can
the
be
state level,
dangerous.
and there's a lot of different municipalities that have vicious and mischievous dog statutes as well. But the dangerous dog is the state definition. We're not trying to argue with that.
But
No, I'm just talking about the preclusion of them from the city.
right.
You can't change the definition of state. That's a fact.
And obviously I think just from a lay perspective, that that sounds attractive on its face. Not being, I'm not up to speed with what Chris has to deal with, but I'll tell you just from an operational perspective, that would, if we were to insert some division without commenting on whether or not it's a good idea, but if we were to insert that type of division, then that would require us to be aware of the consequences that led up to some other jurisdiction designating that dog as dangerous, which I think would present, at the very least, some serious logistical issues. Not that they're insurmountable, but it would definitely be something else that we would have to do.
And we,
Right.
But I think, yeah, I know where you're coming from. So,
Thank you, Chris. You did a great job.
well, thanks for your input, Xandra. I appreciate it. Are you going to be joining us tonight, or have we? Is this all the fun you're
I'm
going to
set
have?
for trial. Well, I'm set for trial. I'll be looking at the revisions. I don't know. I could be called for trial any minute now. So
Okay.
Probably not.
Well, Xandra, pay attention to our Facebook page if you would, as we update the draft versions and as we
Okay.
move forward, we're going to be putting our updates up there. Okay.
Will do. Thank you so much.
Thank you, Xandra. Anybody else on the call?
Yeah, I'm still here.
Sam, are we good?
Thanks
Do you
a
have
lot.
anything else?
No, I'm
no.
gonna go ahead and leave. Thank you.
Thanks,
Bye.
Xandra. See you later. Anybody else have anything? No. All right. Bye-bye.
All right, cool. Thanks.
Let me ask somebody,